Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to The View from Mayor Brown. I'm delighted to be joined today by Chris Milsom from Cloisters. Chris he's an impressive young man, it has to be said. His website, his page on the Cloisters website lists a long list of achievements encompassing the full range of employment law. He has made 24 of his cases been reported in the IRLRs, made more IRLR appearances than any other advocate in both 2016 and 2018. It's impressive. But we're going to talk to him today about the Agoreo case which he was involved in. So, Chris, first of all, thank you and welcome to the Mayor Brown podcast.
Pleased to be here, Nick. Big fan of the podcast.
Excellent. That's what we like to hear. Should we just stop there then? Okie dokie. So let's talk about Agoreo and when did you first get involved with the case? What was the genesis of your introduction to it?
At the pleading stage, it looked interesting on the face of it. Somebody seeking in excess of 2 years loss of earnings on the basis of 5 weeks of employment. And wearing the...
Ambitious.
You can imagine what Croydon Employment Tribunal might have had to say about that. But of course, there's nothing to stop at that as a breach of contract claim. And so that's the stage that I got involved.
So you were involved effectively from the start of the litigation?
From the start of the pleadings, yeah.
And I imagine there's always something very satisfying when you get in at the start of something and you follow it up through the courts and you end up with something in the Court of Appeal, which we're going to talk about in a moment, where you have a significant impact on employment law and the way people understand aspects of employment law.
There's that. There's also the slightly scary moment of did I really say or do that way back when. I'll never forget the moment in the Taiwo case, which made its way to the Supreme Court, where my former head of chambers, Robin Allen, read aloud the submissions produced in the midnight hour for the London South Employment Tribunal about 6 months after I started in chambers. So it has a mixture of pride and mild embarrassment.
And I like terror at some point, I imagine. Yes. Okay, well let's start with the when I say the basic facts, I don't really mean that. What were the contentions in the case at the start? What were they, in a nutshell, the two parties competing over?
There needs to be a bit of understanding of the facts first. So essentially the claimant professed to be a highly experienced teacher and was appointed on that basis in a school, and perhaps we'll come to this, which was going through a rocky patch, shall we say, and the lack of witnesses on the defendant's part, this being in the civil courts, could have been a bit of a problem, and I'm sure we'll touch on that as well. But essentially, she was alleged to have, on 3 occasions in the space of some 16 days, 5 weeks into her employment, used excessive force towards pupils in her care, and she was suspended on the basis of that. And the issue was the suspension a breach of the implied term of trust and confidence, entitling her to resign, and was that the basis on which she left?
Okay, so there's a constructive dismissal claim. She's suspended and she resigns and claims constructive dismissal rather than wait for the outcome of whatever it is. You alluded at the start to, and she was claiming 2 years' pay. So how does she leapfrog from I'm claiming constructive dismissal during suspension to I want 2 years' pay?
Well, the elephant in the room throughout all of this that ultimately the court didn't get to was the Johnson and Unisys question.
Of course. Do you want to just summarise Johnson and
Sure.
Unisys?
So essentially the civil regime saying we're not going to step on the toes of the employment tribunal, claims in this patch are limited to notice pay, which is more generous in the teaching context than elsewhere. It's a term rather than measured by week or month. But we never got there. This was only a liability trial at the end of it, which we won, and then spent some time desperately trying to keep hold of our win.
Okay. So down the road, had liability gone against you ultimately, there would have been a quantum argument that would have had to determine whether had she been constructively dismissed whilst being suspended pending the outcome of a disciplinary, whether that was excluded as a claim by Johnson Unisys,
Exactly.
she had unfair dismissal or discrimination or nothing, or whether Johnson Unisys did not exclude it and so she had some sort of ongoing trust and confidence argument.
Absolutely, and obviously practitioners in this area will be well alive to the slight perversity, which as an employer is very often better off dismissing from a contractual perspective than messing up an internal process, which may lead to an independent right of damages beyond notice pay, or indeed declaratory or injunctive relief. So it is a quirk of the system.
I would venture the possibly heretical thought that the Supreme Court took a left turn when it should have taken a right turn, and that the whole Johnson and Unisys, the need to erect that scaffolding to deal with something possibly indicates that, in breach of contract cases they should have originally limited it to the notice period and not an ongoing period. But
exactly.
That's a conversation for another day. Before we rectify the whole of English employment law. Okay, so the issue on liability, pure and simple, was there a constructive dismissal claim in circumstances where she was suspended?
Yeah.
And what was she saying gave rise to the constructive dismissal complaint?
There are really two limbs to it. One was the failure to offer adequate support during that fairly brief tenure that she had. The other was the fact and manner of suspension, and what was said to be a knee-jerk suspension for impermissible reasons.
Okay, and what did the High Court decide? And you were acting for...
I was acting for the school.
You were acting for the school?
The local authority, which was the big welcoming arms for the schools. So, the local authority is the ultimate defendant. So, 3 stages worth saying. County Court, December 16. High Court appeal, claimant's appeal, July 17. And then, beginning of this year was the Court of Appeal decision.
When we were swapping emails about...
When we were swapping emails at various stages on that long road.
Quite. So, okay, let's start with the County Court. Let's start with the County Court stage. So, at the County Court, what did the County Court decide?
County Court took a pretty dim view of the lack of support allegations, given that, a couple of features really. Firstly, claimant professed to be an experienced teacher and knew that there were challenges with this as opposed to any other classroom environment. You take your kids as you find them, and you've got to be a teacher of all kids with all vulnerabilities, including the 2 children here known thereafter as O and Z, who were undoubtedly a bit of a handful, let's put it like that.
I read the decision.
And so, on that, really, the court's approach was this is a dynamic arrangement. You don't know what you need to do until you're in the zone, as it were, of teaching people, and so support could not be provided, or could not reasonably be expected to be provided from day one, and she left within 5 weeks of starting. On suspension, and perhaps this was part of the problem elsewhere, the court went further than it needed to.
Right.
Because it said that not only was the school entitled to suspend, but bound to suspend. And that set various hairs running.
Quite high.
Because it wasn't a bar that anybody was asking for, but it was a bar that was then seized upon in the High Court as well. Were they really bound to? Were there other options, etc.? But fundamentally, the court found against her on a causation point.
Go on.
Which was she jumped before she was pushed. And so even if there were a breach, the breach was not causative of the resignation because she accepted that there were serious allegations which warranted investigation.
Right.
And so we may come in a few minutes as to quite why the High Court felt entitled to go behind that causation finding. So in short, no breach and no causation.
Right. Okay. So let's deal with the High Court then. So she goes to the High Court, and what's the gist of her appeal, if you can sort of summarise that?
That's part of the problem.
Okay, fine.
She no longer continued with counsel at first instance. She put in grounds off her own back, challenged some of the factual findings, at one stage asked the court to uphold her appeal on the basis that her previous counsel didn't do a good job for her.
It's novel.
Which is novel, and not entirely fair, actually. But something in there caught the attention of a High Court judge on a quiet day, gave her leave. What changed everything was a week before, in fact less than that, 3 days before the appeal hearing, a chap whose name deserves a ringing endorsement, Stephen Butler,
right,
junior counsel from Outer Temple, had some settlement or another, and out of the goodness of his heart picked up a bar pro bono unit brief,
right,
acting for Miss Aguirre on her appeal to the High Court, and put in a skeleton argument, arguing a whole host of things afresh, really. It was, I have to say, full credit to him, it was one of the most impressive things I've ever seen done, to pick up something so quickly and to perform so impeccably at the High Court stage. So full credit to him.
Damn his eyes.
Damn his eyes. Well, he gave us all a trip to the Court of Appeal to put the rabbit back in the hat. But once his involvement was there, it was really about a failure to make central findings, which the claimant argued were essential to making a permissible decision. So partly a reasons challenge, partly a failure to consider salient points, including failure to make findings on just how bad the children's behaviour were, failure to make findings on the reliability of the accounts of these allegations put forward by colleagues. But part of the problem, and I think a lot of people reading the High Court decision will see this, is where is the error of law
yes,
in the county court's
the bit that
decision?
I remember reading and struggling with. So let's talk about the High Court decision, and then let's just try and unpick it a little bit and see where we thought the law rested, or where we fear the law might rest after the High Court decision, and then we'll get into what the Court of Appeal decided.
What set alarm bells ringing, I think, in the High Court's decision? In fact, let's take a step back first. We're dealing with the implied term of trust and confidence.
Yes.
And there's components to that. It's trite law, but perhaps not trite law in the eyes of the High Court, which might explain some of the problems. Is there conduct which is likely to or calculated to destroy or seriously damage the relationship of trust and confidence? And if there is that conduct without reasonable and proper cause?
Yes.
As an aside, that's why it's almost impossible to see how a fair constructive dismissal could ever arise, because if you've failed on those two grounds as an employer, trying to discern a potentially fair reason is going to be needles and haystacks.
We've all tried.
We've all tried, and to the best of my knowledge, we've all failed. If anybody listening has an example of a fair constructive dismissal, I'm sure they'll write in. But what Mr. Justice Foskett did in the High Court is essentially say that where there's a suspension, his words, not mine, suspension has to be shown to be reasonable and or necessary in order to defeat a contractual breach claim.
Yep.
And because it could not be shown that suspension was necessary, she had a good claim, and therefore the liability findings were substituted in her favour. There are some curious phrases elsewhere in the judgment which the Court of Appeal picks up upon. The High Court said that it had reservations about some of the important conclusions reached by the first instance tribunal, took the view that alternative findings were quotes justified in the circumstances. I'm very hesitant about expressing reservations about assessments of the evidence made by the county court, but I'm a little concerned about some aspects of the foregoing. Curious phrasing.
Sort of quite interventionist.
Quite interventionist. And reading the judgment, and indeed this is something that the Court of Appeal was very much alive to, it looks like a first instance tribunal or court starting matters afresh.
Yes.
And that's why I say, but beware the talents of a good advocate, because that was the path that a fresh pair of eyes on all of this in the form of a new counsel perhaps distracted the High Court into following.
So the bit that sort of made headlines, I remember at the time, was you only got to suspend people if it was both reasonable and necessary.
Yeah.
Which obviously, you were talking about the county court raising the bar. That seemed to be raising the bar to suspension.
Yeah.
For suspension, and a lot of times suspension happens, and whilst of course in the real world, you ought to think carefully about suspension, etc. There's often a tendency to err on the side of safety and suspend than err on the side of safety and not suspend, and
Yeah.
They seem to be altering that balance. And I remember we had discussions about whether you could draft a suspension clause that altered the balance, so it said we will have the ability to suspend you if we consider it appropriate,
Yeah.
or something. So if you could contractually re-engineer that.
And in a particularly concerning context, because this is a school environment with safeguarding obligations.
Yes.
So if the necessity bar is applied there,
Yes.
the average employer should have been seriously concerned.
Really, really concerning.
Yeah,
So your clients decided to go off to the Court of Appeal.
we did indeed.
And what was the basis for the appeal to the Court of Appeal? Well, again, if you're able to summarise
Sure.
it crisply.
So there were three grounds, really. One, for reasons that we touched upon, this was an impermissible substitution exercise by the appellate court. Two, that suspension is a neutral act, and therefore you don't jump from there to a necessity test. And thirdly, even if it is capable of being conduct which is likely to or calculated to seriously destroy or damage trust and confidence, it's a reasonable and proper cause test rather than a necessity test. So in short, impermissible substitution and set the bar too high.
Yes. Okay. And in terms of the response to the appeal, was the response, broadly speaking, High Court got it right and we stand by what the High Court did?
Yeah.
Fine.
Yeah.
Okay.
And going with the mantle of necessity. So essentially saying that necessity is the right test here, because if a suspension is not necessary, it's without reasonable and proper cause, which was ambitious.
Yes, as I'd say, there's the ambitious word again. Okay, so what happened in the Court of Appeal?
We won, which was obviously what matters from the client's perspective. In terms of the wider points on why we won and how that might apply more extensively, Lord Justice Singh giving the lead judgment, who I think is playing an increasingly important role on employment-type disputes in the Court of Appeal, gives the best analysis and summary of principles on what the role of an appellate court is when looking at standards of reasonableness and, by extension, the band of reasonable responses, for example. And perhaps we'll expand on that in a couple of takes. But that's the first point. The second point, the question of whether suspension is neutral or not is legally irrelevant for the purposes of this whole exercise of breach of trust and confidence. Again, we might want to spend a couple of ticks on that. And thirdly, no role for a necessity test. Court of Appeal didn't really understand what it means to say that something is reasonable and or necessary. It's a bizarre conjunctive. But in any event, it's a question of reasonable and proper cause rather than necessity. So the bar was set too high.
Okay. And as far as we know, that the case is now at an end. It's not going any further.
I hope so.
Yes. Back the win and move on.
Otherwise, we'll have to cut the podcast short. No, I understand that's the end of it.
Right. Okay. So let's just work our way through that, because there's obviously quite a lot in there. Can we talk about the neutral act point?
Yeah.
When I was reading the Court of Appeal, I did think that to argue that suspension is a neutral act was was an interesting concept when, of course, it takes you out of the working environment. It's not really a neutral act. I understand why the Court of Appeal didn't evaluate that point and said it wasn't the issue, but why was it important to argue about, why were you arguing that suspension was a neutral act in terms of, rather than being a reasonable and appropriate act or whatever?
I think it's important to say what was communicated at the time of suspension.
Right.
The suspension letter said that essentially this was no more than a precautionary suspension to enable a fair investigation to take place.
Mm-hmm.
We were hamstrung at first instance by the fact that the only individual giving evidence for the employer was a teaching assistant who made one of the original allegations of the excessive force had been used. So we did not have, at first instance, the individual who wrote the letter and took the decision to suspend. In circumstances as well, where there are 3 incidents over a short space of time, the head teacher looks at least one of them and doesn't take the view that further action is required. There's limits to how much can be said about her departure, but the judgments speak for themselves. But the executive head teacher of this branch of schools comes in after the 3rd allegation, sees an email from the only witness that we had, and takes a different view that suspension is appropriate, but very much frames this not as a safeguarding issue in the letter communicating suspension, but this is a precautionary measure.
I understand.
Now, the follow-on implications of that are, can we really rely upon safeguarding issues if they weren't cited and communicated at the time? Because what's the evidence that they were in the mind of the decision maker, particularly when the decision maker isn't in fact there as a witness?
Yes.
And so trying to make suspension as anodyne as possible,
I understand,
was potentially important.
Understand.
There was also a question, really. I mean, a case of Meze, which was a permission application heard by the Court of Appeal on interim injunctive relief in a suspension context, was only a permission decision. And that permission decision made it very clear that it changes the status quo, can't be regarded as a neutral act, etc. It seemed to us that the Court of Appeal hadn't grappled with that in a substantive appeal yet, and so therefore, since we were there anyway, why not?
Why not?
But I think ultimately nobody's going to be terribly surprised by the view that the court took, which is Meze is of more importance than simply being a permission decision. It's reported in the RLRs, etc. And it isn't a neutral act. If on Monday you're at work with your colleagues and on Tuesday you're told to go home and not communicate with your colleagues, how can you possibly say it's a neutral act?
But
So,
we know it's not part of the. It's not.
It's not part of
It's not the critical evaluative
Exactly.
path to work out whether suspending someone is a repudiatory breach of contract,
Right.
mutual trust and confidence.
or for that matter, a detriment in a whistleblowing and discrimination context. And so, I think that what the Court of
possible to
Appeal,
argue.
I think what the Court of Appeal was keen to do is say this label of neutrality is legally irrelevant. It depends on what lens you're looking at this.
Okay.
In a breach of contract case, is it a breach of the implied term? In a whistleblowing discrimination case, is it a detriment, etc.? Just leave aside the word neutral, it adds nothing. And I think also what the court did here is look at the ACAS code and say, well, there's no inconsistency here. I mean, one of the arguments that we were running is that there is a potential incoherence in the ACAS code saying you've got to make it clear it's not a disciplinary sanction. Well, if you're doing that, how can it be regarded as anything other than neutral? On that, I think there won't be any great surprises amongst practitioners either, which is it's not a neutral act, and the ACAS code doesn't say it's a neutral act either. It just says it's not a disciplinary
It's
sanction.
not a conclusion.
So no great surprises on
Okay.
that point, I don't think.
So let's talk, and I was interested in the point you mentioned, which is the first of the 3 points, which was the role of the appellate court and the knock-on consequences in connection with band of reasonable
Yeah.
responses. So
Yeah.
just partly conclusions on appellate court, but also the tie-in as you see it to band of reasonable responses, because
Sure.
of course that's the point that will come up again and again for
Yeah.
employers. Most of our clients are keen to avoid the additional trip to the Court of Appeal, so
Absolutely.
the jurisdiction of the appellate court is of less relevance. So yes, so talk us through that.
I think part of the reason why the High Court felt like it had a bit more freedom is that there was very little oral evidence heard at first instance. There was one of the complainants of one of these individuals making the allegations of excessive force and the claimant herself. And so you see this flavour in the High Court judgment of, well, I'm in as good a position as His Honour Judge Woolwick was, because there's no evidence on this point. What the Court of Appeal makes clear is when you're looking at reasonableness or trust and confidence, you as a judge or you as a tribunal are engaging in an evaluative exercise. And what's set down in paper as your reasons is always going to be an imperfect summary of that evaluative exercise. And it doesn't matter whether one witness is called or 20, that evaluation deserves the respect of the appellate court unless something's gone plainly wrong. And if you think about the number of occasions in which we're in the language of reasonableness or fairness, reasonable adjustments, band of reasonable responses, fair dismissal, implied term here, reasonable and proper cause, etc. The general message I think to get from Agareo is don't go off to the EAT expecting leave automatically. You have to show that evaluation is plainly wrong, not simply that you disagree with it. Maybe Triton well-established law, but I think the summary that the lead judgment that the Court of Appeal gives on that point is exemplary and will be used elsewhere. And it may be that in fact, is the more important part of this decision than the suspension issue. But we'll see.
And is it your take that it also feeds through into the employment tribunal looking at an employer's decision on, say, to dismiss someone or not, that they should be similarly hands-off, is my term, you have used it, when it comes to an evaluative process looking at the decision that the actual decision maker, the employer, made in an unfair dismissal context, whether there was when they're looking at a band of reasonable responses to disciplinary issues.
Yeah, I mean, the anoraks amongst the listeners will recall a few years ago that there seemed to be a space of unfair dismissal cases where EAT was overturning ET's decision, and cases such as Kneebound, etc., just saying, hold off, give some respect to the first instance tribunal, don't start using the label substitution mindset every 5 minutes just because an employer disagrees with an ET's evaluation. And I think this will be grist to the mill, even where it is not a witness-heavy first instance decision.
So then if we come to the third and final point, which is is it a necessity test before you can impose a suspension?
Yeah.
And the Court of Appeal knocked that on the head. In essence, was that simply restoring contractual orthodoxy? The test is for mutual trust and confidence is what it is, and therefore, if you're not, you don't elevate that in a suspension constructive dismissal as opposed to any other form of constructive dismissal.
Exactly so. I mean, there's two ways of reading the Court of Appeal's decision on this. One is to say suspension, you've still got to show that suspension is both calculated or likely to seriously destroy trust and confidence. But there's a kind of slight twist towards the end there, which suggests an alternative reading, which is that a suspension is to be presumed to be that destruction or damaging of trust and confidence. And so what you're really talking about in the suspension context is reasonable and proper cause.
Right.
You see the slight difference there. Yeah.
Interesting. I confess I hadn't picked that up from the judgment, so that's an interesting take on things. In practical terms, if you move forward now, litigation's at an end, employers' suspension is a regular event in connection with disciplinary issues. Is there any advice you would be giving to employers that says, look, in the world in which we now live, if you are looking at suspension, absent anything specific in your rules and procedures about how you go about in the circumstances in which you suspend, what you really want to be thinking about is this.
Yeah. It may have been that a trick was missed on the employee's part in this whole field. Many of us are aware of how contractual discretion has been considered recently, Braganza, etc.
Yes.
Taking relevant considerations into account, excluding irrelevant considerations. Whether investigation or the need for a fair investigation in and of itself is a relevant consideration, if you haven't actually considered, well, what does an investigation look like if this person is still here? I think is a moot point. The general practical point I'd make is really, why are you suspending?
Yes.
Why is suspension inappropriate, even if you don't have to show necessity, orthodoxy restored? Why is that an appropriate or reasonable measure to take? And set it out in writing. Give the reasons why you're making the decision, albeit in cursory terms, in writing. Because if I still think, not least because the Court of Appeal really upheld the Meze analysis, it's not a neutral step.
It shouldn't be. I think it's clear. It shouldn't be a knee-jerk reaction.
It should not be knee-jerk, and the way in which suspension is communicated matters. The way in which allegations are communicated matters. And so the practical advice I guess I give is this: why are you suspending? And if you have a reason for it, set it out. But precautionary measure in and of itself, precaution against what? I mean, if there is a genuine concern that the investigation will be interfered with, then all well and good. But knee-jerk or an assumption that every serious disciplinary investigation requires suspension is, I don't think, you don't get a license for that from Agoreo.
I think sometimes employers think, because they say this does not prejudge the outcome, therefore it's okay.
Yeah.
And that does not follow as night follows day. Equally, the argument you come across quite a lot is, look, this is a serious allegation. If this is true, then we don't want them anywhere near our workplace.
Yeah.
Therefore, we're going to suspend them, because whilst we're investigating whether this is true, we have to err on the side of caution. Take an example. You're accused of stealing some money.
Yeah.
We do not know whether you've stolen the money, but we're going to suspend you because if you've stolen the money, we don't want someone in the workplace. But I've not actually seen it ever formulated in writing in those terms.
Sure.
And I suspect what employers may tend to do is not put any reasons in and then wait to be challenged on the reasons, because presumably, I don't know this, but I'm assuming that in your case, she writes and complains about being suspended and then claims constructive dismissal.
She resigns on the day in which suspension is communicated.
Interesting.
Hence why the first instance tribunal says, well, actually, this isn't really about suspension. This is about the fact that there's an investigation that you'd rather not have.
And we've all seen
jumping
seen
before pushed, etc. I guess what I mean in terms of writing, perhaps not necessarily in your communications with the person you're suspending, but have a clear sense as to why that decision is being taken, rather than, particularly given as here, it was the elephant in the room question in circumstances where the individual who made that decision was not giving evidence.
Yes.
So something resembling an evidence that there has been an independent decision on that particular case, rather than that's just what we do in these parts, is the way forward.
I agree. I'd agree with that completely, and it's something we've cautioned against. But equally, in many cases, in many cases, it takes quite a lot of nerve for the employee to claim constructive dismissal ahead of the disciplinary finding, because if they're wrong, they're completely wrong, and they're having to set themselves up to get over the constructive dismissal hurdle to get to the dismissal, to get to damages. Whereas if you hang on and wait to be dismissed, then you have the damages. So sometimes some of the constructive dismissal claims are about trying to avoid having a finding on your record, rather than I want to make money. But I totally agree with the main thrust of your comments. And in a case where, I don't know if you saw the case in the EAT the other day, the 3-year suspension case.
Yes.
Where you're thinking, goodness me, that's clearly the employee didn't want to claim constructive dismissal there for whatever reason, tried to find another way of putting pressure on the employer, and ends up being on suspension for 3 years with no end in sight.
You see it a lot in the public sector. I mean, suspensions that go for months and years. And NHS, I think, is a particular culprit on that front. It's investigations, thoroughness becomes a proxy for delay.
Yes.
And from the perspective of the individual who's languishing at home, it can cause real problems.
Yes, I can completely understand that.
And I think one of the comments that I think Lord Justice Elias made in Crawford was, it'd be interesting to take a tally of how many people actually come back following long periods of suspension.
Yes.
Answer would be not many, in my estimate.
Very few. It's fewer. It'll be fewer than long periods of sickness, but the similar. there'll be similar challenges, I
Yeah.
imagine. But I think it's not a neutral act, and therefore, if you took someone out of the workplace for 6 months or 9 months, an excessive suspension, very difficult to come back from
quite.
that. No smoke without fire. Workplace moved on. Okay, Chris, that is fascinating. Thank you very much indeed. That was very clear and helpful, and I think chimes with the sort of advice that we've been given to clients about not using suspension without thinking about why you're suspending. I said that when I bored you on list of questions that we'd end with a personal round, which was books, films, or music. I'm always interested in what people would recommend and why. So I think you said book. You were going to go with the book option.
Yeah. Well, we've there's a 6-week-old baby in the Milsom household, so the requirement of any book is that it's short. So we live in interesting times, and there's been a really interesting pattern, I think, over the last couple of years of modern writers going back to kind of Greek myths and all that sort of stuff, and modern retellings. And there's 2 examples that I think are terrific that I've come across recently. One is book by Camilla Shamsi called Home Fire, which is an absolute corker. It's a retelling of Antigone, really, in the context of a Muslim Home Secretary being particularly harsh on cases of extremism and the kind of cultural divide there, and where allegiances are owed. Parallels with Shamima Begum, I think, given this was written long beforehand, are interesting. The other is Everything Under, which, aside from anything else, has the most beautiful front cover by...
Never judge a book by...
but this is a cracker. And it's a kind of reversion of Oedipus by a young writer called Daisy Johnson, and it is absolutely beautiful. I think it's the first thing I've read in ages where the moment you finish the last page you go back to the first and start again. It's just beautifully written. So those 2 are my requests, and they're short, which is great.
Which is very good. Very good. Okay, well, thank you very much for that. I always think you have no idea what people are going to say or why, and the circumstances in which they're reading or listening to music. I remember we had one of my fellow partners on, who's a global mobility partner, and she chose a piece of music. I said, why that piece of music? Well, because my father used to sing it to me every night before I went to sleep.
Gorgeous.
And you just suddenly see a completely different side. I love that side, so that's good. Excellent. Okay, well, Chris, listen, many thanks for coming in. Hopefully we'll tempt you back again at some
Absolute
point.
pleasure.
And thank you indeed. Take care.
All the best.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.